All right, everyone. Lyric Armstrong, your real estate agent and advocate. Today we're just going to get into it. Middleton Court, landlord tenant, Michigan. Again, this is not legal advice. This is commentary, and by all means, consult a professional for your own specific concerns. But let's learn something. Let's see what happens in Michigan court today. So we got some hearsay. We got some objections and some facts. Okay, we're going to have hearsay, objections, and facts today. I'm going to put all three on at some point in time because it's a long day. All right, let's get into it with Judge Middleton. All right. Where did he go? There he goes. He's there. He is there. We are here on the YouTubes doing YouTubey things. Law Nerds Unite. Here we go. Remember, we keep the sound up. So if you're plugged into your ears, turn down your sound. This is with the hopes that you can hear us and all things in the background. Maybe we'll hear someone talking to their attorney like we did in a specific performance case the other day. All right, let's see. What do we want to do now? We're going to do some facts. All right, facts. We're going to start off with facts.
Good afternoon. We're going to start our busy afternoon.
Good afternoon, Judge Middleton.
Thank you all for saying hello. Had a little technical glitch that Autumn helped me with.
Logging in remotely.
But it's showtime here in just 3 minutes.
He has a busy docket. We try to focus on his landlord tenant docket.
So let's get ready.
So let's see what we got going on today.
For viewing on this beautiful day. It's 85.
While we're waiting on the court to get on record
right now,
go ahead and do YouTube things. Like, subscribe, and share. Let's help the algorithm, help people learn as we are here to learn as well.
Because I was busy.
Let's speed up. Let's speed it up.
Good afternoon.
All right, we got some motion.
Hello, Ms. Zablocki, can you hear me?
Yes, I can.
Good afternoon. This is Judge Middleton. I'm here at the court in Centerville, and this is a landlord tenant hearing. It's entitled Boost LLC versus Kelly Zablocki. Attorney Lori Hines is here on behalf of the plaintiff. This has to do with a property on Water Street in Constantine. Your landlord has filed what's called a termination of tenancy.
Yes.
Okay, reminder, termination of tenancy does not mean that you didn't pay. We had, I'll probably do a video on it. We had someone who was on in court with Judge Middleton, and they were kind of disturbed about the tenancy being terminated, though that they have been paying. And they didn't feel like they had any reason for termination, but they were on a month-to-month or a week-to-week, whatever their lease was. So all they needed was to give notice. Your landlord does not have to have a reason. If you are on a month-to-month or your lease is up, they can just let you know they want to terminate and give you the proper notice to that effect, or they don't want to renew the lease, whatever the proper notice would be, and they can use the property for whatever they want, whether that's to repossess it themselves, to be in the property, or to not necessarily repossess, but to possess the property itself, to occupy themselves, or to put another family member there, or to rent to someone else, or even to sell it. So they don't owe a responsibility to you to have a reason to terminate the tenancy. This is why owning your own property is much when you can is is an important thing, because now you have more control over the ownership compared to when you're a tenant and the landlord says you got to get out. So that's what's going on here. Well, we'll see. That's what happened.
I wish that he would move.
Yes.
And I'm going to bring the next guy in, and I can advise both of you at the same time.
Okay, I guess he's the second tenant. Or occupant.
Good afternoon, sir. Are you Rigoberto Gutierrez?
Yes, sir. The missus is here as well. She's just off to the
All
side.
right, and that would be Chanel. Let
Yes,
me
sir.
advise you both, as well as our earlier tenant, that as tenants in a landlord-tenant proceeding, whether it's a non-payment of rent or termination of tenancy case, you have the following legal rights. Sir, I'm asking you not to vape while we're here on a court proceeding. Let's pretend like we're actually doing a court.
Oh, Judge Bryant, tell him we are in court. Judge Bryant says it a million times, not because she loves to hear herself talk, but because she wants to make sure everyone can hear her. And when you come into court on Zoom, when you're on Zoom, you've had this experience, it takes a minute before you can hear the other person speak because you're connecting to the audio. So she repeats it over and over again as people come in. Bottom line is, when you are in court, you are to be stationary, upright position, and no smoking, no driving. I think you can drink water, but that's about it. So, if you have a beer can or anything like that, you can't do any of that because you are in court. Though it's a different platform, it may not feel as regal as going down to the courthouse, but that's by choice at this point because the courts are open. So you could come down to the courthouse. Zoom is a convenience. So Zoom is a convenience. You have to respect that convenience by respecting the court and not smoking, vaping, or anything else
You have the following
that you would not do in
legal
court.
rights. You have the right to obtain counsel for representation in this matter. Excuse me. If you cannot afford an attorney, a legal aid attorney may be available to help you. You have a right to a trial by a jury or by the court. If the action is for non-payment of rent, and if you are eligible for any assistance from any source, you may not need a judgment to receive that assistance. The summons and complaint should be sufficient, although that's not always accurate. If the plaintiff is agreeable, the Citizens and Mediation Services, Inc. may be available as a possible source of case resolution. If both parties are agreeable to mediation, court can help set that up. If you do reach an agreement with the plaintiff and a consent judgment is entered by the court, you would waive the rights listed above but have the following additional rights. The judgment may not be enforced until 3 business days had passed. You could move to set aside the judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment would be set for a landlord-tenant hearing. However, if the judge did not find in your favor, the original judgment would stand. Our legal aid representative, Meg Bauer, has joined us, and she's on the feed if there's consultation needed. Ms. Zablocki, your landlord served a notice to quit on you on April 28th. This is a week-to-week tenancy. You've apparently been there for some time, but they want you to move. What's your position?
Your Honor, I moved out over a month ago.
Oh. Do you have any objection to them taking immediate possession?
No.
Laura, let's see if I have a judgment here.
I think you should, Your Honor.
Yes, I do. All right, now they're not asking for any money in this hearing. They could come in a future hearing and ask for, but I will note, defendant has vacated.
She did not
Plaintiff may-
do this with the forwarding address, though. That's
Yes,
part of-
I'll mention that. Plaintiff may take immediate possession. When you move, you're supposed to turn in your keys and give your forwarding address within 4 days of your moving.
I'm aware of court. I had told her that I moved out. They've already cleaned out the apartment within like a couple days after I had moved out. And I know that because the neighbors were my friends. So they kept updated on some of the things that were going on. So she was aware that I moved out.
Let me put you in a breakout room with Ms. Hines, and you can give her your forwarding address. Then you're free to go on about your business. But you've already moved. They've got the possession back. If they are going to seek damages, you'll get notice and have a chance to be heard on that. So you're good to go. So join the room that says join. And when Ms. Hines is finished, you can go on about your business.
Okay, so bottom line is, let's make sure that's it for, okay. Bottom line for Madam Tenant, she's already moved out, that's fine. The keys and the forwarding address are necessary because as the judge said this particular hearing, they're not requesting any back fees or any tenant what is it called? Landlord rent. Oh, so sorry. They are not requesting any arrears for the rent, and they're not requesting any fees at the time. However, when you moved out per se, they need to double check to make sure that there's no damages. So that's what the forwarding address is for, and that's everyone. I don't necessarily know the days to be the same with regards to Michigan versus another state versus another state. There may be like 24-hour notice of change of address, or 3-day notice, or 4-day notice, but whatever that notice is for your state, that's where you need to abide by. And so look that up or consult a realtist or real estate agent or a lawyer in real estate that can help you identify your rights as well as your responsibilities. Because if you don't, then you could not get your security deposit back, and then you could go to court and say, oh, they kept my security deposit, but there was no damage. So why did they keep it? Well, they sent you an invoice stating that there was damages, and in fact, you didn't have a forwarding address properly noticed, and consequently, you never got it, so you didn't fight it in the right amount of time, so you forfeited your security deposit in the end. Those things can be the outcome if you are, in fact, not giving proper notice and receiving the invoice or the mail later, and also the check, right? Like, you want your money back, you better tell them where to send it to. All right, so Lyric Armstrong, your real estate agent and advocate. We're going to try and take this case by case so that you don't have big chunks and long chunks of videos to watch right now. And then maybe we'll connect a little later, but right now that's what we're doing. So hopefully this helps just a little bit. We'll get back into Judge Middleton's court in real quick, because thankfully he has a good long docket.